Thank you very much. For the debate, the member for Carleton, Mississippi Mills.
Thank you, Mr. Speaker. Although Bill 118 is well-intentioned, it would necessarily infringe on a property owner's right to the peaceful enjoyment of his private property. And although it states in the bill that the Act does not constitute an expropriation or injurious affection for the purposes of the Expropriations Act, the bill clearly appropriates a private property right, the right to privacy and security, as it allows the public to, in effect, trespass on private property. This bill also revives a discredited concept that the Crown/public has the right to the land between the high water mark and the water's edge. There is no such right. As reported in issue number 14 of the Tiny Cottager in the spring of 1999, in an article titled "Tiny's Shoreline, A Legal History," I quote, "The first major test case of the Crown's ownership of shoreline property was decided almost 30 years ago. In 1970, Mr. Justice Stark of the Supreme Court of Ontario held in the trial of Walker versus the Attorney General that where one of the boundaries of the land granted by a Crown patent is to be a boundary of water, then that boundary is at the water's edge, unless the grant reserves in a clear and definite words a space between the lands granted and the water boundary. Thus, Walker owned his property to the water's edge of Lake Erie in the township of Bertie near Fort Erie. This decision was affirmed by the Supreme Court of Canada in 1974. I also note that private property rights extending to the water's edge was affirmed by further rulings as reported in the Lawyers Weekly on July 2, 1999, in an article titled "Water Boundaries, Who Owns the Beach?" I quote, "In fact, most southern Ontario properties fronting on large lakes, extend to the water's edge by operation of the original Crown grant. For many decades, the Ontario Department of Lands and Forests and the successor, the Ministry of Natural Resources, contrary to well-established common law, vigorously promoted the use of high water mark, meaning the landward side of the beach, as the boundary separating patented uplands from lands forming the bed of the adjoining water body. On the basis of that notion, the beaches were considered by Crown officers to be part of the bed of the adjoining water body and therefore unalienable Crown lands, except where a water lot had been granted. The concept was raised to the status of legislation as part of an omnibus bill in 1940, the Statute Law Amendment Act, but was found to be unworkable and was repealed in 1951 by the Beds of Navigable Waters Amendment Act. The author of the article explains further that the courts have been consistent in applying the common law rule, placing the boundaries of inland non-tidal riparian properties at the water's lowest mark. The principle was confirmed by the Supreme Court of Canada in Attorney General versus Walker et al. There are only two exceptions to the rule. Number one, if the words of the grant clearly reserve a space between the water and the granted uplands, or number two, if the boundaries of the granted uplands are clearly defined by reference to an original plan of survey, which is unequivocal in demonstrating an intention on the part of the Crown to retain a space between the water and the granted lands. Discussing the case of Ontario versus the Roundtree Beach Association of 1994, the author states that, similar to Gibbs, all parties to Roundtree agree that if the lands were granted to the lake, then the boundary of the patented lands was the water's edge at low water, and also that Roundtree was not appealed. In other words, the attempt to expropriate private property between the high water mark and the water's edge is not new. It has been adjudicated by Canada's highest court, which decision has been accepted by the Crown and was previously legislated and repealed as it was deemed unworkable. In addition, this bill not only infringes on private property rights, it also imposes a duty on private property owners, a duty not imposed on other private property owners for the high crime of owning beachfront property. Given the history of this file and the infringement of private property rights, I cannot in good conscience support this bill. In conclusion, legislators should be defending, not eroding, individual common law private property rights as they form the foundation of our Western developed civilization, our democracy, our freedom, and our prosperity. Thank you.
Thank you.